Yeah, I don't have a written presentation. I tried to write, but every time I wrote down something, my mind went back to the period before 1994, the discussions we've been having before the adoption of the new constitution. So everything, I wanted to write something, I said, no, I've read about this, I've heard about this, I have said something about this, and now it's 2017. What I'm trying to say is that, the issues that we're discussing, we have been discussing them prior to the adoption of the new constitution. The question of community policy dates back to the interim constitution of 1993. We're currently sitting with the SAHRC Act 68 of 1995, an act that predates our constitution. We were sitting with regulations that regulate CPFs that go back to 2001. And these are still interim regulations, meaning is that we do not have regulations basically other than what we have is the interim regulations. So clearly, we are sitting with a SAHRC Act that needs serious overhaul to make sure that it is consistent with our constitution. We're talking about democratic policing, but specifically on accountability and oversight. Now let me start with the NTP. In its introduction, it says, safety is a core human right. It is a necessary condition for human development, improving quality of life and enhancing productivity. When communities do not feel safe and live in fear, the country's economic development and the people's well-being is affected, hindering their ability to achieve their potential. Now, I want you to connect this with Section 198 of our Constitution, under security services, Chapter 11. National security must reflect the resolve of South Africans as individuals and as a nation to live as equals, to live in peace and harmony, to be free from fear and want, and to seek a better life. Now, we're talking about people, we're talking about communities. We don't have a national police station. Neither do we have a provincial police station. We have local police stations. And this is what should be central as we speak of democratic policing and accountability and oversight. How good a police station is normally a reflection of how good the station commander of that police station is. You have a weak station commander, that will be reflected in the policing in that area. So, for me, this is our starting point. And now, the question of community policing, as I said, starts from the interim constitution to the 1995 Act. But what we have now in terms of the new constitution is basically Section 263 that deals with the powers of provinces. And 263 of the Constitution talks about provinces having the power to monitor police conduct, to oversee the effectiveness and efficiency of police services, to look at the relations between the police and communities, to look at effective, visible policy. Now, this is what we have in section 263. But I think I owe you an explanation as well, because the same title here says Western Cape Police Ombudsman. Why so? My office, for instance, is a direct creature of the Western Cape Community Safety Act. Now you ask yourself a question that policing is a national competence, it's not a provincial competence. But the Constitution reminds us that, or tells us that provinces have got an important role to play in policy without necessarily taking the management and control of police out of the hands of the National Commissioner, whose responsibility it is to manage and control the police. But again, when you have that section 263, which is also followed by section 265 of the Constitution, which again empowers provinces to investigate or establish commissions of inquiry to investigate allegations of police inefficiencies and the breakdown in relations between the police and the communities. Now you have the Western Cape being the only province so far with a police act, with the act that seeks to monitor police conduct. We've got to look at also Schedule 4 of the Constitution, which clearly says that there is concurrent legislative competence between the national and provinces when it comes to enacting legislation on policy. So this is the source of authority of this office, which would mean that any other province, in exercising its responsibility, can then establish this. Now, the Constitution again establishes civilian oversight authorities in Chapter 11 for both the Defense Force, the intelligence services, and the police. The relevance then of my office comes when we've got instances of poor service delivery on the part of the police, where the police fail to execute their mandate in the manner that they should in terms of Section 253 of the Constitution. So we've got a direct correlation between an efficient police service and public confidence and trust in the work of the police. And the fact that we've got civilian oversight over the police was to ensure that we don't go back to the abuse of power as we had prior to 1994. The elephant in the room is that when we discuss these issues, we don't want to talk about the past. We want to pretend as if we don't have a past. We don't want to talk about the past which is in the present as we're trying to formulate our future in terms of democratic policing and ensuring that communities play a significant role in their own policy. But the problem is that when we speak of this community policy, the police that I've been interacted with, whether it be at national or at the level of the province, always complain to say that there are so many oversight bodies over there. They're tired of these bodies of oversight. but really, can they afford to retire? Because this is a constitutional imperative. Question of accountability. It's normal. Security services don't want to account. When they do account, they do so reluctantly. And where do you locate then that within, a framework of democratic policy? But again, do we have the same understanding of what is meant by democratic policy? I don't think so. Just to look at community policing, the police have got their own understanding of their role within CPFs. Whether it be a local CPF around a particular police station, or at the cluster level, or at the level of the province. The CPFs themselves, that is the civilian component of CPFs, have got their own understanding. Now, the provincial executives, in the case of my office, which would be the MSC for community safety, also they've got their own understanding. They've got their own understanding of how to measure the functionality or otherwise of the CPFs. There's no standard instrument of measurement other than for the Department of Community Safety in the Western Cape, for instance, to be concentrating more on the expanded partnership programs. Now, this creates a problem because we've got the critical components of this partnership, which is supposed to hold the police accountable, not having the same understanding about their roles and responsibilities, about the expectations from one another in ensuring that we do have a viable partnership. It becomes a problem. CPFs will be complaining about being undermined by the police, and the police saying that the CPFs want to do things that they are not supposed to be doing. They want to control the police. The CPFs and the police will also be getting up against the Department of Community Safety, that it doesn't seem to appreciate its role or how it wants to interact with these people. So it becomes a problem. What is it that will then make this partnership work? One of the things that I want to propose, to enhance accountability of SAHRC would be perhaps Major General Muteti, would be for us to come up with a common understanding in the form of a memorandum of understanding between the three components of this partnership. The civilian component of the partnership, the police themselves, and the department representing the provincial executive. Because without that, this partnership is doomed to fail. And there's no way in which we can allow it to fail. When earlier raised the question of torture by the police, apart from raising it as a violation of human rights, for me what is critical is what happens to the reports. Like the ICT report, for instance, of 2011, which clearly highlighted, these incidents of torture. Who took that report seriously? Did the Human Rights Commission institute an investigation around these issues? Did the portfolio committee, which is, another civilian oversight, take that report seriously so as to summon the police to appear before the committee? Did the portfolio committee on justice, which is another civilian oversight structure within Parliament, take that report seriously? So what happened? We heard earlier on in the morning what Amnesty International, the stats that they were giving us. Who's dealing with those issues? So, in my discussions, with the police around these matters, the refrain is always that of the CPFs don't want us to have any say. Now it's the police saying this. But the Provincial Commissioner of Police in all provinces has been given a direct responsibility to establish CPFs from local station level to the cluster level up to the provincial level. And the station commanders are part and parcel of the local police station CPFs with a designated officer or two. The same at cluster level. The cluster commander, the Western Cape is divided into 16 police clusters with 150 or so police stations, divided into 16 clusters. So at cluster level, the cluster commander, in terms of the law and the regulations, is supposed to be part of the cluster CPF. At the provincial level, the law requires that the Provincial Commissioner of Police is part of that. But these things are not happening. And how do we enforce this? Where is the commitment and will to make sure then that we are able to have all the things that we speak of in the introduction of the National Development Plan, which is supposed to be our 2030 vision, Section 199 of the Constitution, which is supposed to be guiding us. These are the challenges that we've got to deal with. Secondly, SAHRC says that CPFs cannot play an oversight role over them because Section 18 of the SAHRC Act, I think in F, speaks of a joint identification of problems and a joint identification of solutions. Therefore, if CPFs are required in terms of Section 18 of the SAHRC Act to be involved in the joint identification of problems as well as the joint identification of solutions, how can they still play an oversight role over the police? Again, it comes to the question of interpreting things in the way that will suit each partner. Because CPFs have got their own understanding and docs have got their own understanding. So for me, the real challenge is how do we really make these oversight bodies work? The Civilian Secretariat has not been empowered to investigate complaints against the police. The only reference in the Civilian Secretariat Act, for instance, is Section 6 of that Act, is a reference to the Civilian Secretariat looking or assessing the capacity of SAHRC to deal with complaints against them. So then the Office of the Ombudsman then, in terms of the provincial statute, has actually then been empowered to investigate complaints that relate to police inefficiencies as an oversight mechanism giving teeth to Section 206(3) of the Constitution, and also ensuring the realization of Section 206(5) of the Constitution. Thanks.
And our final panel.